and a motion for modification of custody. I'm not sure. Or a motion to enforce custody order agreements, I guess is how it's framed. But I think the child support maybe predated this other motion. Ms. Hawkes, do you know where are we, or Ms. Hawkes, I'm sorry, where we are at as far as you all's position with regard to child support in this case with Judge Murphin, which has been sort of separate somewhat from the custody?
Your Honor, it's my understanding that father has a child support obligation of $342 effective December 1st, 2024, and that we've been doing a dollar for dollar offset for the arrears that were owed by mother. And I believe that's about to be satisfied. And that we were just here today on a review of that order.
Okay.
Whether it would continue.
Okay. That is my recollection. And remind me, Carvin is how old now? He was 6 when we started all this, or thereabouts.
Is going to be 16 or 17, excuse me, in August.
17 in August?
Yes, ma'am.
Okay. And will he graduate this next school year from high school?
No.
The courtroom comes to order with all parties present, including counsel, caseworkers, and mental health representatives. The judge confirms appearances and clarifies that this remains a 4D case involving child support oversight. At issue today are multiple filings, including motions related to child support review and a motion framed as enforcement or modification of custody. The court carefully situates the procedural posture, noting prior orders and the child's age progression. This opening establishes that today's hearing is not a trial, but a focused review of compliance, parental conduct, and whether judicial intervention is warranted.
He won't. So he's going to be a junior?
Yes.
Yes.
And he'll turn 18 as a senior?
Yes.
So instead of just having 1 year left of child support, there's 2?
Yes.
Okay. Now, Mr. Brazil, from what you can ascertain with regard to, and by the way, Ms. Blakey has, for most of the majority of this case and currently been pro se or self-represented. So this, and she's filed numerous motions on her own. This is a notice of hearing and motion to enforce. Mr. Brazil, do you feel like you have a handle on her motion?
Yes, Judge.
Are you ready to argue it today, or do you want it set for evidentiary hearing?
The court turns first to child support, confirming the father's obligation and the dollar-for-dollar offset addressing prior arrears. Testimony clarifies that the obligation began December 2024 and is nearing satisfaction. The judge thoughtfully considers the child's age, noting he will turn 18 during his senior year, extending the support period. This exchange reflects the court's duty to ensure statutory compliance while accounting for real-world timelines. No enforcement action is triggered here. Instead, the court confirms continuity and accuracy, reinforcing that child support remains separate from the custody disputes raised later in the hearing.
I think argument is probably fine. I will say, and I would proffer to the court that my client visited with the police that reported to his home that evening, and none of them had any concerns regarding anything like intoxication. And so if we really were going to get into it and have to deal with that question of was he intoxicated, was he not, then I would ask for it to be set for evidence. My hope is that that's not necessary and we can kind of resolve this motion and move forward. I think ultimately the bulk of her motion is more of upset with how co-parenting is going and less of, the specific request for the substance abuse or things like that. I'm kind of a little wondering if this was like an AI generated request. I don't have any real reason to believe that that was necessarily there. Just the formatting and things like that seem like it might be a chat GPT generation.
All right. Ms. Blakey, I'm not familiar with that stuff yet enough to hopefully after our October training, maybe.
Attention shifts to the mother's motion. The judge acknowledges that she has largely proceeded pro se throughout the case and has filed multiple motions independently. Counsel for the father confirms readiness to argue, while reserving the right to request an evidentiary hearing if intoxication allegations become central. The court listens carefully, signaling openness but caution. This moment underscores a recurring judicial challenge, balancing access to justice for self-represented litigants while maintaining evidentiary standards and procedural fairness for both sides.
Be a little better at recognizing some red flags, but I'm not at this point. Ms. Blakey, would you please summarize for the court your motion and your requests or prayers for the court with regard to this motion?
Yes. Are we gonna deal with the child support after or first?
We will at some point discuss
Okay.
it. For now, that's the main thrust of this is the motion that you filed on June 5th.
I have written down what I'd like to say. I did my very best to shorten it and stay respectful. So I'd like to say on the record regarding my motion. At a previous hearing, Your Honor reminded us that when things escalate or break down, we are to seek resolution from the court. My intention is not to punish or shame Chad, rather to improve the health and function for all three of us. I filed this motion out of...
The mother addresses the court directly, reading a prepared statement. She emphasizes that her intent is not punishment, but safety, stability, and improved co-parenting. She raises concerns about alcohol use, emotional intimidation, and a pattern of behavior she believes compromises the child's well-being. She describes feeling unsafe and overwhelmed, asserting that medical responsibilities have fallen solely on her. Her tone is emotional but controlled, framing the motion as a request for accountability, therapy, and court-supported boundaries. The court allows her to finish, recognizing the gravity of the allegations while reserving judgment.
Concern, distress, and need. The need for health, peace, safety, and boundaries. The need for support, protection, and accountability. It is my responsibility to advocate for Carbon and for my family. Part of the evidence I've submitted includes a list of medical appointments in order to make known the patterns I believe reflect Chad's lifestyle choices and have compromised his reliability. I believe his longstanding issues with alcohol and personal habits are interfering with his ability to meet Carbon's needs consistently and safely. To my knowledge, Chad has not scheduled or attended one medical appointment since the custody change, not even when Carbon is in his care. Chad relies on me for all of these needs now.
What relying on?
Me for the medical appointments.
Because I remember very distinctly you wanting to be involved, make appointments, go to appointments, be part of things, and you got your wish granted, right?
Yeah, and I don't.
The judge interjects periodically, clarifying specific issues and narrowing the scope. The court reframes parts of the testimony, identifying scheduling medical appointments and communication breakdowns as central concerns. Importantly, the judge distinguishes emotional impact from legal proof, signaling that while the court hears the distress, relief must align with evidence and authority. This exchange reflects judicial restraint, acknowledging lived experience without prematurely validating allegations that require substantiation through admissible proof.
Mean to be rude or pushy, but if I could finish what I've written down, it's really it's important to me that I convey all of this.
All right. Well, I'm trying to take notes here. So one of your issues is that you now are the primary person that schedules everything.
Well, I'll finish.
All right.
Due to this event that based on the motion that I filed, a friend suggested that I should not be compensating for Chad's lack of involvement, and I do agree. But when Chad suggests instead to allow Carbon to drive into Wichita alone for the appointment before he's ready to drive on major highways, or for the appointment to be pushed back to accommodate Chad's tattoo clients over Carbon's medical care, or altogether not provide medical care, I cannot stand for this risk or the neglect. If I'm being honest, I do cherish having these moments, these appointments, and this time with Carbon. But
Counsel for the father responds firmly but methodically. He denies any evidence of intoxication, noting police interaction produced no concerns and emphasizing the absence of alcohol-related arrests. He challenges the timing of the motion, pointing out the delay between the alleged incident and filing. Counsel argues that miscommunication, not misconduct, drove the conflict, highlighting that the mother herself used the child as an intermediary, contrary to her claims. Exhibits show the father requesting medical involvement, undermining assertions of neglect. The defense frames the motion as frustration with co-parenting rather than a legal violation.
But I do think that Carbon needs both parents, and if I'm going to be the only one tending to the appointments and other needs, I would at least ask Chad to have a respectful conversation with me instead of lashing out when he has issues, if there's a disagreement. Perhaps Chad feels he's giving us this time out of kindness, the appointments. Perhaps he's relieved to have less responsibility. Whatever the case, I just cannot tolerate the intimidation or the aggression that I experienced during this event. What other people see is a version of Chad that he chooses to show publicly, a kind, successful father, but I'm asking the court to acknowledge that I am on the receiving end of a very different version. There are moments when I am looked at and spoken to by Chad with such deep disdain and contempt that I cannot help but feel unsafe emotionally, spiritually, and physically. I'm almost done. This is a reality I've lived with silently for years, and I did not ask for this. I've asked for peace and health. I shouldn't be expected to suffer in silence or with unknowing that I have no clue if Carbon is in danger behind closed doors with Chad. All I know is that Chad's words do not align with his actions, and no one can convince me that I shouldn't be afraid in these moments. My heart, soul, and intuition knows what it knows, and I know these situations are not right, they're not healthy, they're not safe, and they're not okay, and I can no longer allow these things to happen, and that Carbon and I should no longer endure these outbursts or this